Is it still allowed to question the Supreme Court, or is jail the immediate consequence? In a time when every word is monitored and questions can lead to imprisonment, what's left of democracy? Recently, AngKampanero Representative Perci Cendaña, political analyst Richard Heydarian, and the controversial figure Larry Gadon have been charged with indirect contempt simply for speaking out against the Supreme Court's decision to declare the impeachment complaint against Vice President Sara Duterte unconstitutional, according to the complaint filed by attorney Ferdinand Topaccio, attorney Mark Tolentino, and Rolex Suplico, well-known allies of the Duterte administration. The three allegedly violated the dignity of the judiciary through their critical statements on the ruling. But if we examine it closely, what law did they really break? Here's what Representative Cendaña said. It's obvious this is the Duterte playbook against critics. Either you get trolled, or you become a victim of legal harassment. It's the same old story. Don't they have a new strategy? He added, they should look in the mirror. They themselves have displayed absolute contempt for the rule of law. They have never shown respect for the law unless they can weaponize it and use it to their advantage. Representative Cheldiocno strongly condemned the filing, stating, what's important now is that the impeachment complaint against Vice President Sara Duterte proceeds. Like 80% of Filipinos, we believe she must be held accountable to the people. On the other hand, Richard Heydarian remains confident in the court. I have full confidence in our highest court and respected justices to not bother with frivolous petitions by politically motivated groups. Isn't it ironic? The same personalities known for harassing others are now using the system to silence criticism. So the question stands, did Cendaña, Heydarian, and Gadon really violate the law? Under Article 3, Section 4 of the 1987 Constitution, the right to speak and express opinions is clearly protected. In Chavez versus Gonzalez, 2008, the Supreme Court emphasized that public discourse, especially on matters of national concern, should not be suppressed. In Re Soto, 1949, and People versus Alarcon, 1958, the court itself ruled that fair and well-intentioned criticism of its decisions does not amount to contempt of court, unless there is a clear and present threat to the administration of justice, such as incitement to violence, threats, or obstruction of proceedings. None of these apply to the statements made by the three. Furthermore, Representative Cendaña enjoys legislative immunity under Article 6, Section 11 of the Constitution. He cannot be held liable for remarks made as part of his duties as a lawmaker. Their statements are not crimes, they are criticisms. And in a democracy, criticism isn't just allowed, it's necessary. So why is this being used now as grounds for punishment? The answer is simple. This is clearly legal harassment. Some figures are using the legal system as a weapon of political intimidation. The goal is to scare others into silence, and that's the most dangerous part. If this kind of petition is allowed, it sends a message to the public. Don't question, don't speak, don't criticize. The only acceptable behavior is obedience and silence. If we stay silent now, tomorrow it might be you they silence. So here's the call. Like, share, and comment on this video so more people can learn the truth. And don't forget to subscribe to AngKampanero, Tinig ng Katotohanan, Tunog ng Kaysayan on YouTube. Thank you to our new subscribers. Your support keeps us fighting. Let's keep the bell ringing for truth, justice, and freedom.